everyone, welcome to the latest edition of Charity Chats. My name is Rustomji. I'm a partner at Shakespeare Martineau, and I'm joined today by regular panellists Charles Mesquita from Quilter Cheviot and James Saunders from Kingston Smith. These sessions we talk about latest issues that occur to us really, and one of the items I'd noticed in recent weeks was an article around founder syndrome in charities and the different motivations of charity trustees, whether that's a force for good or a fatal diagnosis, or the challenges that can sometimes create. So I'd be interested, Charles, James, in your thoughts that occur to you in terms of what are the motivations for people getting involved in charities, and whether the challenges that come from that can be managed and overcome, or whether sometimes that's just too much of an obstacle.
Yeah, do you want me to kick off? On the positive side, I think that the founder syndrome, or founders, are very much the entrepreneurs of the charity sector. So absolutely should be encouraged. They generally start with a good idea. They've identified a need. It starts off the sort of kitchen table. There's no particular plan, and it's just being driven generally by one individual who've got no restrictions. So in that respect, absolutely fantastic. The bit that I have, I suppose, some reservations about, and this comes, and Catherine, I think I could direct this one at you, is around the legal documentation. Certainly those that I have come across have some really bizarre wording in around protecting the founder. And I just to me, that seems complete contrary. And I've never understood why they are put into the documents. Because if somebody's got a good idea and they're a driving force behind it, they're likely to remain to have a huge influence on, and shouldn't need to have sort of things inbuilt into your constitution that protects them irrespective of what they do.
Yeah, I mean, I absolutely agree. Actually, for operational charities, I don't think it is appropriate to have founder trustee provisions written into the governing document. But for instance, when it's a grant-making charity from a couple or a family, I can understand why they always want to have some sort of family connection on the trustee side of things. So they sort of say, well, this is the founding trustee, and they can then be replaced by somebody else from that family, which makes me think it's a bit more the kind of philanthropy that we would see in the States, that it's that kind of succession planning and getting the next generation involved in charitable giving. But I think that's a big distinction when it's a grant-making charity purely, as opposed to an operational charity, which I think should be allowed to evolve without the founders stifling that maybe, or seeking to control it.
Yeah, I'm not even sure that actually... Sorry, go on, James.
On that point in particular, Catherine, the legal side, is there not the potential for a conflict between a founding, a protection of founder clause and the fundamental objectives of the charity, which are to operate for the beneficiaries?
Yes, so you would be required to have a sufficient number of non-related, non-connected trustees, but sometimes the founder provisions will be a meeting wouldn't be quorate unless the founder was also present. The retirement provisions wouldn't apply to the founder, so they could continue to be a trustee. So fundamentally not necessarily a conflict, but I think depending, especially with an operational charity, I think the motivations there of why would a founder want to control how that charity develops to such an extent, rather than sharing that with the trustees, potentially with any senior management, so that it's allowed to breathe. I think sometimes I just find it a bit stifling where founders can restrict a charity too much.
I just start from the principle that there shouldn't be anything different in this. I think you lead to all sorts of unintended consequences and problems. And so even with a family charitable trust, I actually would prefer it to remain silent, and that the charity itself would understand the benefit of having a member of the family who knew the founder, on the board and see that as a benefit rather than as a requirement and a consideration of loss. So I find it I find it difficult to justify having special clauses in there, which ultimately end up, and you get these unintended consequences. The other thing, I mean, for the 2 or 3 people I've met who've actually founded things and done it with passion and motivation and everything else, the one interesting conversation I always have with them is about, okay, fine, you've created this legacy. So have you got any plans of how you are going to exit that, and have you thought about how you leave that legacy and its values, and what happens if you've left and then suddenly the ethos of the thing changes? What are you going to feel about that? And you get some quite interesting conversation, but most occasions people I've spoken to haven't really got that far in the thinking.
Yeah, and it's interesting because I think among charity lawyers, it's said in jest, but it is often the case that founder syndrome is fatal. There is no cure for that. So if you've got an individual who literally is holding on to their charity so tightly, they have no intention of ever letting that go and be allowed to develop going forward. They always want it to be about them.
It seems to me the much more modern approach to setting up charities in recent years has been to approach them and avoid that founder syndrome problem by saying, actually, I want to make a charity that can operate without me.
Yeah.
I want to move them in that 5-year cycle, 5-year startup period to a point, I'm starting it up. These are the intentions, but fundamentally, I want to step away in 5 years' time. I've heard that a lot more recently with startup charities than any sort of, I want to stay involved and it's my family trust. Now, that, of course, that's the nature of family trusts, and there is essentially going to be historical money. But I think that there's been considerable change recently in how people set up charities. It's more accessible to set up a charity these days and make it an operational charity than the family trust, albeit there are obviously the family trusts are still there.
Yeah.
But I think your problem here is that the intention at the outset turns into something that's different as you've invested so much of your emotional and time into an organization, and that it's probably surpassed your expectations coming through. So this to me is an evolution as much as anything that creates its own issues, and then trying to become to be dispassionate becomes very difficult. And also it's a control thing.
Well, I'm not, but it comes back to what's the motivation for setting up the charity in the first place. If it is a very personal, emotional reason that you set up a charity, and I've got personal experience of this, having been on a board of a charity where it was a bereavement that created the charity. However, if the purpose is more an environmental purpose or something that's more legislative, they want to create change, something like that. That I think leads to that is you've got far less chance of there being founder syndrome, because in that case the founder is likely to want to create a purposeful charity rather than an emotionally driven charity organization, if that makes any sense.
Yeah, and I think it's interesting, as we've talked about sort of charitable foundations that have that deliberate aim of spending out in their lifetimes, and we want to apply all of these charitable funds to address this issue. So I think it is interesting when a founder says, well, actually, my intention is this is not going to be me. I'm going to set it going and then deliberately step away. I think there's quite a difference with that. I think that is more the ethos of philanthropy, to say, actually, it's about what I'm giving out, not what I'm also receiving in return.
Do you find, Catherine, when setting up charities these days, that the Charity Commission considers whether there is the potential for founder syndrome, maybe not calling it that, but looks at the objectives and says, are the objectives dispassionate? Are they disparate? Can they be fulfilled without that founder syndrome setting in? Because it seems to me that ought to be something the Charity Commission should consider when setting up a new charity.
Yeah, I think the Commission, they would look at whether the objects are charitable at law. So they'll look at the wording of that, and then they'll look at the composition of the group of trustees. And at the outset at registration, they're looking at, could there be any undue influence? Are there too many family members that are obviously related, that we haven't got independent trustees? So if there's a conflict, it would affect too many of the trustees. So they do definitely look at that at registration. I'm not sure that would be an ongoing question, so that you could change the trustees after that point. And I'm not sure it would be necessarily flagged to the Charity Commission that they would see there is too much of a leaning potentially where the charity is able to be, I suppose, commandeered by a group of trustees.
I don't think we should expect them to either as a regulator. I mean, that's getting much too much down into the detail, because you can have one very dominant individual. In fact, it could have been the one who'd made all the money, and it may, you know, and they're going to be a force on the board irrespective.
Yeah.
And again, one of the things you find with family charitable trusts is, you know, once you've made effectively a donation into a charitable trust, it's an irrevocable gift. But of course they don't always see it like that. They see it still as their money, and because they're the trustees, they have control over it. And so I think it's, but I think there are also sufficient guidance and rules around dealing with conflicts and everything else. I mean, I know from personal experience of sitting as a trustee, where, you know, you have a very strong founder who's still heavily involved, not as a trustee, in fact, but it is a delicate moving around of making sure that sufficient controls are in place, and that things are being, without you know, removing the fantastic work that particular individual has done. And they have very much so been behind the driving the organization, the success of it. And the other issue, which I think certainly in the early days, is of course not just time these individuals put in, but they also put their own personal money in, which isn't necessarily, they don't necessarily see as a charitable donation, but they're funding it because the organization wouldn't exist, survive, or thrive without it. So, and again, the law doesn't really allow for that sort of payback, in whatever form that may be. So a lot of these are really subtle and delicate issues.
And I think they still come back to the points that we've talked about before around different personality types, you know, and how people behave in a group where there's shared decision making. And I think some people can play nicely with other children more naturally than others. And I think you do see that dominant personality, or, you know, it's just almost kind of taking over the airtime, that they're taking more time and space than any of the other trustees. So I think this is part and parcel of that challenge. I think, James, you're a fairer trustee. You seem a kind of, you share the space with others rather than.
I'd like to think so, yeah. Certainly my own experiences in the end, where I had something like this personally, you know, actually I walked away from the board because there was too much of a control. There was too much in certain areas. Now, as Charles was saying, in that case, it did reflect an awful lot of that person's effort over, you know, and there was a lot, you know, enormous amount of good work done. And I think we see that, you know, in many, and you know, it's a bit, I don't think it's really to say it is predominantly smaller charities where this is going to happen. The one that you used as an example in the lead up to this for us, Catherine, was a much bigger one that's grown much quickly and is a bit more of a corporate charity, I think. And in that case, I should think it was more about the growth, the speed of growth that caused them. It was growing pains, I would have thought. Yeah. And I would have, quite often growing pains are not quite the same as you know, founder syndrome.
Yeah.
But that's any organization, doesn't it? I mean, that some of those situations, but that's not the issue. It's the dominance of one individual and their influence on and their ability to be dispassionate and not forget that actually it is a charity that they're running, not their own personal company.
Yeah. But Charles, James, thank you very much. I think it's been an interesting discussion. For those listening to the recording, do give us your thoughts, observations. Feel free to disagree with us strongly. We like a bit of challenge, and we look forward to seeing you on the next Charity Chats. Thank you.